that we are getting ready for the release of Maazi Nnamdi Kanu. By the 10th of October, the Supreme Court is getting hot. There seems to be a lot of changes to the Supreme Court of Nigeria because of this very matter, because the supporters of Maazi Nnamdi Kanu, both those abroad and those inside Nigeria, are not taking it lightly with the Supreme Court, with Nigeria. And that's what we're looking at, because this new development just dropped, and here in Noble Media, we'll be giving it to you immediately. This is the full gist. Now, the Kanu's lawyer declares Supreme Court judgment unconstitutional. The lawyer of Maazi Nnamdi Kanu has come out boldly without fear to say that the judgment the Supreme Court gave for Maazi Nnamdi Kanu's case does not follow the Constitution of Nigeria. One of the lead lawyers representing the 10th leader of the newspaper of Biafra, IPOB, Maazi Nnamdi Kanu, has described the Supreme Court's December 2023 judgment in his case as unconstitutional by incurring and travesty of justice. We must move on. In a public notice obtained by the wrestler, we are reading from the wrestler newspaper on Sunday, Mr. Joko, speaking on behalf of Maazi Nnamdi Kanu Global Defense Consortium, Maazi Nnamdi Kanu Global Defense Consortium, further the Supreme Court's ruling in Federal Republic of Nigeria vs. Maazi Nnamdi Kanu 2022, which overturned the October 2022 judgment of the Court of Appeal that checked and quashed all terrorism charges against Maazi Nnamdi Kanu. The Court of Appeal had ruled that Maazi Nnamdi Kanu's extraordinary rendition from Kenya divested the Nigerian Court of Jurisdiction to try him. On December 15, 2023, however, the Supreme Court reversed that decision, reasoning that because the Court of Appeal did not determine Kanu's guilt or innocence on the merit, the order of the charge could not be regarded as an acquittal under Section 36, Subsection 9 of the 1999 Constitution. So it was the Supreme Court that overturned the judgment already given for Nnamdi Kanu to be released. And that is what this lawyer, Joko, is saying, that judgment of the Supreme Court is against the Constitution of Nigeria. The Abbas Court also relied on a stay of execution granted by the Court of Appeal on October 28, 2022 to preserve the charges, a move that paved the way for a retrial. Ndoko described this reasoning as logically absurd, constitutionally dangerous, and inhuman. A judgment delivered in ignorance of binding precedent. Let's look at it again. That judgment by the Supreme Court is logically absurd, constitutionally dangerous, and inhuman. A judgment delivered in ignorance of binding precedent. We must move on. According to Mr. Ndoko, Nigerian law is clear that once a court lacks jurisdiction, its proceedings are null and void and cannot be revived. Please, as you are watching this video, if you are one of those that believe that Maazi Nnamdi Kanu should be free, come down the comment of this video and type free Maazi Nnamdi Kanu, free Biafrans. Except if you are afraid, if you don't have courage. But if you're courageous enough, come on the comment of this video and demand for the freedom of Maazi Nnamdi Kanu. He said authorities such as Madu Paul versus Invalid, Abba versus State, and Obebo versus State. In his argument, a discharge for want of jurisdiction is there for the end of the matter, not a provisional holding. He's saying that discharge that was given to Maazi Nnamdi Kanu by Court of Appeal is supposed to be the end of the matter. The lawyer also faulted the reliance on the stay of execution issued by the Court of Appeal, noting Nigerian criminal law does not allow acquittals or discharges to be stayed. States apply only to civil matters and interlocutory rulings. Nigeria is not obeying their own law. By suspending the discharge of October 13, 2022, the Court of Appeal preserved the charges already quashed as void. The Supreme Court then leaned on this contrivance, ordered a retrial, summoning both Abuja and the Bible expressly forbidden. So the Supreme Court is actually perverting justice. They know the law, but they are not following their own law. Come under the comment of this video and demand for the freedom of all detained Biafrans. Type free all detained Biafrans, free Maazi Nnamdi Kanu. Those that are imprisoned at home and those that are imprisoned abroad that are fighting for freedom, demand for the freedom in the constitution. Ndoko further argued that returning Kanu violates the constitutional prohibition against double jeopardy. Section 36, Section 9 prohibits returning a person after acquittal. He pointed out, stressing that once the Court of Appeal, a competent court, quashed the charges as unlawful, that is charge carry finality. In the eyes of the law, Kanu's case is supposed to have been finalized and he's supposed to be free at the moment. According to Nigerian law, treating it as tentative on guilt or innocence tested on merits effectively abolishes protection against double jeopardy. The lawyer stated, we must move on. This lawyer also cautioned that the precedent being set by the Supreme Court is dangerous, warning that if this logic stands, then any discharge based on lack of jurisdiction can be overturned on a trial on the merits is conducted. That reduces jurisdiction, a constitutional safeguard, into a meaningless technicality. This is what the Supreme Court's case is redoing the Nigerian Constitution. The defense team also pointed to the international dimension of the case regarding the June 24 High Court of Kenya's ruling, which declared that Kanu's abduction and transfer to Nigeria were unlawful, involving torture and breaches both the African Charter and the International Convention on Civil and Political Rights. Let's look at it again. June 24 High Court in Kenya came out on June 24, declared that Kanu's abduction and transfer to Nigeria were number one, unlawful, number two, involving torture. Kanu was tortured, and number three, breaches both the African Charter and the International Convention on Civil and Political Rights. We must move on. This ruling, the lawyer noted, reinforces the Court of Appeal's 2022 finding that jurisdiction was divested. By disregarding this and insisting on a trial, Nigeria risks deeper international condemnation and potential sanctions. Nigeria could be sanctioned. Nigeria could be sanctioned. In the Supreme Court, the lawyers could get it hot if they continue with the way they are treating on the Kanu's case. Don't forget to come under the comment and demand for the freedom of Maazi Nnamdi Kanu. This little things we are doing is a way, is going a long way. The case against Kanu is currently before the Federal High Court in Abuja, where the prosecution closed its case on June 20 after calling 5 witnesses from the Department of State Services. Kanu's legal team, led by Chief Anu Agabi, has filed a no case on mission with Justice James Omotoso expected to rule the case on October 10. As October 10 is coming, everybody must be alert. Kanu's legal team, okay. Njok, however, maintained that this entire proceeding is tainted by the Supreme Court's interim ruling and unconstitutional state that preserve void charges. In law, the trial is a nullity. Summing up his position, the lawyer